It's time again for the Insiders with Chuck Chvala and Scott Jensen, sponsored by the Wisconsin Counties Association and the Tommy G. Thompson Center on Public Leadership.
Hi, I'm Chuck Chvala, former State Senate Majority Leader.
And I'm Scott Jensen, former Assembly Speaker.
We're the Insiders. So, Scott, now talk about insider baseball. This is insider stuff. The governor is deciding to distribute raises without going through Joker committee, which both of us served on. And he is also deciding to talk to agencies or to communicate with agencies to say that you no longer have to really worry about the Joint Committee on Administrative Rules for long-term decisions to kind of permanently stop the legislature from adopting rules that are going to go into effect. Obviously, there's something that's changed out there. Why don't you tell the viewers what we're talking about here?
So the Wisconsin Supreme Court has had two recent decisions that took away powers that the legislature has had for decades, powers that you and I exercised as legislative leaders. And now we're beginning to see the governor's team sort of try to define the edges of that, to try to broaden the powers as much as possible. The court shifted authority away from the legislature and gave it to the executive branch. And now the governor's trying to see how far he can push that. So the court said that once a budget or a bill appropriates money, that's where the oversight from the legislature essentially ends, and that the executive branch then can spend those funds in compliance with the law. We saw that because the Republicans on the Joint Finance Committee were holding back stewardship funds and not allowing those funds to go forward because they didn't necessarily agree with particular investments that were going to be made with those. Now the governor's saying, well, given that court decision, I can hand out raises because we budgeted 3% for raises, so I can hand out those raises without checking in with the Joint Committee on Employment Relations, which since the 70s has had a role, along with the governor, in signing off on contracts and raises. And it's not just the dollar number, it's all the different things, so like how many days you get off, what sort of practices there are, all those sort of things. And so the governor's, if that stands, the legislature has lost a significant power there. The same thing essentially happened on the rules, the administrative rules. The Joint Committee for Review of Administrative Rules for, 50 plus years has had the ability to suspend a rule that was promulgated by an agency and then require them to come in. There's a discussion, they go back and forth, they decide if any changes will be made to the rule. The court has said, no, that committee does not have the ability to suspend a rule. You have to do it by the whole legislature voting for it and the governor signing it. The governor who is, of course, trying to promulgate the rule in the first place. So now the legislature has lost that authority. I think there's still questions about whether or not the standing committees like the Education Committee or the Natural Resources Committee have the authority to suspend rules, but they took that away from the other committees. So that is a huge shift. I mean, this is the sort of thing that will make a difference in people's lives, but there'll probably never be much media coverage about it at all. This is a big shift in power by the court and by the actions of the governor from away from the legislature and toward the executive branch. It's something that will redound in Wisconsin politics for a long time. And it's something that Democrats may regret, right? I mean, there may be a time when Republicans actually elect the governor again, and they'll be able to exercise all those authorities. So boy, this is a big shift. And I just don't think there's been enough attention paid to what this could mean for the future.
I think Scott's got a lot of good points there, but let's go back. Why did this happen? And I'll tell you why it happened. The legislature under Robin Vos and this Republican, it seemed like forever majority in both houses that was put in place after the 2010 elections and the redistricting there. The legislature got way ahead of itself in terms of exercising too much power. And what happened is, I mean, if you think about it a little bit, the old power of the purse does reside with the legislature. That's why my biggest focus and Scott's biggest focus when we were leaders was to focus on the budget. Why? Because if it isn't appropriated, it can't be spent. Well, what happens here now is the court is saying you don't get two bites out of the apple. You appropriate that money, then the governor gets to spend it. And guess what? You're not going to be able to veto individual projects. You're not going to be able to give a Democrat, for example, if you're a Republican, a project, and then come back and have your administrative rules committee or your Joker committee say we're not going to approve the appropriations. You approve 3% raises. You're not going to be able to come back again and say, we're not going to do that unless you take care of DEI. When the legislature got too rambunctious about this, what happens is the courts, as the third party in our triumvirate here, the legislative, executive, and judicial, they try to reset. And they find a way within this set of laws and the Constitution that we have. And that's what happened here. Now, I've been talking about appropriations and the comeback after that. I think that what the court, even though I am a legislative supremacist, I do believe that the court probably made the right decision there, and I can see it making sense for just a lot of different reasons, even though the governor would have the ultimate say, although they had to get the appropriation from the legislature. When you talk about administrative rules, I think it's somewhat different because administrative rules, as you would find if you went to Wisconsin's law school or any others, we have some of the most administrative rule-oriented professors in the country there. You'll find out that that is a very significant part of what's happened. And it's something that over the course of time, starting with Franklin Roosevelt or even before, has been really big. I'm sorry I'm getting in the weeds on this. But there is, I think, a better argument for the legislature on the administrative rules side. But on the other hand, at some point, they have to let legislation that's passed be implemented. And who is going to have the final say on that? And I think the court has now moved it much more in the direction of the governor. It will be interesting to see as we go along. Will there be certain elements, and Scott's raised a couple of possibilities, as to where this might be brought back more a little bit in the legislative side. But I'll tell you what, I think Scott, the final point he made was a really good one, and that is whoever doesn't have the governor's office is going to be mightily upset by the changes here, because if you don't have the governor's office, you're definitely going to have to focus on that budget, because that's the only place where you're going to have any leverage as a legislative leader or as a legislative body.
This one's going to actually make a big difference in Wisconsin politics for a long time. And I'll bet the Supreme Court ends up revisiting pieces of this, because there's a lot of questions about how far their decisions extend, and the governor's testing that. So I think they'll have to revisit some of this.
We'll see you next time.
You've been listening to The Insider with Chuck Chvala and Scott Jensen, sponsored by the Wisconsin Counties Association and the Tommy G. Thompson Center on Public Leadership.